Today's webinar, Progress on Evidentiary Rules Reform in the States. Is it needed? And if so, how does it get done? Sponsored by the Law and Economics Center at the George Mason University Antonin Scalia Law School. I'm Ashley Evero-George, Assistant Director of the Law and Economics Center, and I'll be moderating today's discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. Our commitment is to developing original, high-quality law and economics research and educational programs like the one today to further enhance economic understanding and provide information that is useful in the legal and policy debates surrounding these issues. We thank all of you for joining us today to be part of that ongoing dialogue. Our two experts today each come to the discussion with impressive backgrounds, researching and analyzing the development of evidentiary rules reform. So that we can reserve time for substantive discussion, I will give only a very basic introduction rather than extensive bios. To learn more about each panelist, I recommend that you click on their names in the email invitation you received from the Law and Economics Center to join the webinar, or visit the LEC website at masonlec.org, where more details are listed. With us today is Alex Dahl, who is General Counsel of Lawyers for Civil Justice in Arlington, Virginia. We also have Lee Mickus, who is partner at Evans, Fears & Shuttert in Denver, Colorado. We are delighted to have them both sharing their expertise today. We will save some time for audience Q&A at the end. If you have a question, please submit it using the Q&A box at the bottom of your screen. Please identify yourself in the text of your message and keep your questions short so that they can be readily incorporated into this virtual format. With that, I will turn it over to our panelists. Mr. Mickus, why don't you get us started on the new amendment to Rule 702?
Thank you so much, Ashley. I really appreciate the opportunity to speak to all of you today and hope this will be informative. So just to start off the discussion, as you all probably are aware, the amendment to Federal Rule of Evidence 702 becomes effective on December 1st, so in just a couple of weeks. And this federal amendment provides the context for framing the question of forthcoming state action to reconsider their respective standards for gatekeeping and admitting experts, and whether they are going to go forward and adopt the changes reflected in the federal amendment. I want to start with an overview and give you an idea of where Alex and I are going to go today. We're going to start by describing the amendment itself and what it does to change practice and to change the language of Federal Rule of Evidence 702. Then we're going to identify the problems that convince the advisory committee and ultimately the Supreme Court that these amendments are necessary and essential to change the practices that have developed among federal court practitioners. We're going to examine and discuss the fact that these very same problems that have been seen in the federal courts are also present in the state gatekeeping practices, and they require the same clarifications to bring things in line. Next, we'll address how courts have focused their attention on the wrong admissibility standard historically, and in many instances, they draw upon analyses of the judicial responsibility for gatekeeping that don't actually even interpret Rule 702, but instead interpret court descriptions of the responsibility that actually predate Daubert itself and have been blindly carried forward for the last couple of decades. Next, we'll consider how language that judges and practitioners use in describing the gatekeeping responsibility affects the way admissibility is examined and how that needs to change. And then we'll conclude with some thoughts about how practice needs to be affected by this amendment and how this impacts state considerations on moving forward with amendment to their state gatekeeping standards. And then, of course, we're going to invite questions. So with that overview, let's dive into it and let's talk a little bit about what the amendment to Federal Rule of Evidence 702 is going to look like. And Angelica, if we could get that first slide, please. So on the screen, you see the amendment as it is going to be effective in a couple of weeks. The underlined bolded text is new and added to Rule 702, and the double strike through is a language that's going to be deleted. What we see here are three elements that I guess I want to focus and that Alex is going to expand on here in a moment. First, we see in the top section that the amendment pours the standards that judges must use right into the text of the rule. Next, we see that explicit reference to the court as being the decision maker of the admissibility criteria that are laid out in subsections A through D. And then finally, we see this change to 702D to address what was called in the advisory committee rulemaking hearings as overstatement, and that relates to an expert that states a conclusion or a degree of confidence in the opinion that the methodology simply doesn't support. Alex, turn it over to you.
Thank you, Lee. I would like to drill down a little bit on the three changes that you have just touched on about this language. The three big takeaways for this amendment are, first, that the court must decide admissibility. Really, if you could boil down this entire topic to one problem, according to the Rules Committee's analysis, it's that courts are giving expert evidence to the trier of fact without first deciding on the admissibility and deferring to the jury about making that decision about what it means, whether it's sufficient or not. And so this clarification, the words "the court" in the new rule amendment, mean that the court must make this decision before sharing any of the expert evidence with the trier of fact. The second takeaway is the standard of the burden. The profferor must satisfy the Rule 702 requirements by a preponderance. It uses the language "more likely than not," which is the same thing as preponderance. But what this means is that there is no such thing as a tie goes to the runner or a deference to allowing evidence in. There is a burden. The profferor must satisfy that burden before evidence is admissible. And the third and final change of this rule is that the gatekeeping responsibility of the court is ongoing. In other words, it isn't sufficient for a judge to rule on admissibility and then not listen to what comes out of the expert's mouth, but rather every opinion that is offered by the expert must meet the standards of 702. So this means that the responsibility is ongoing, and it's for the very reason that Lee just described, that the Rules Committee, the Federal Advisory Committee on the Rules of Evidence, found that there are important instances where experts will, after describing the facts and the methodologies and everything that they're supposed to do, will then offer an opinion that exceeds the methods and the reliability that they have just described by indicating a higher confidence in their findings or something like that. So this point is put in there to make sure that the courts and parties understand that this is not just a qualification question, but rather that the standards of Rule 702 apply to everything that the expert testifies about.
Let's, Angelica, we can move to the next slide, please. All right, so I'd like to talk a little bit about how we got here. What were the problems that we were seeing in the courts that led the advisory committee to make these changes that we've described? And let's start with the need to pour the preponderance standard right into the text of the rule. As we kind of hinted at, this rule doesn't affect a change in the substance of the rule. It's intended to clarify how courts are approaching, how litigants are approaching these issues. And this is particularly notable with respect to pouring the language of a preponderance standard right into the text of the rule, because the preponderance standard has been the applicable standard all along. Daubert makes reference to this in a footnote. It identifies the preponderance standard as that which the courts need to be applying. Daubert also, in the text, makes reference back to a case called Borgelli, which itself references Rule 104A. All of these point to the fact that courts are supposed to be applying a preponderance of evidence standard, more likely than not standard, to all of the admissibility criteria that are listed within the rule. Well, what's the problem? The problem has been that a number of courts, and many courts, have invented and then applied judicial policy approaches toward gatekeeping that simply aren't consistent, are fundamentally inconsistent with this preponderance standard. And they draw these from various places, and they're framed in slightly different language, as you can see laid out. But the long and the short of it is, all of them amount to a judicial thumb on the scale in favor of admitting an expert over excluding that expert, which is fundamentally inconsistent with the idea that the proponent of the evidence bears the burden of establishing that all of the elements are met by a preponderance of the evidence. So, for instance, predominantly in the Eighth Circuit, but we see picked up elsewhere, we see courts apply the idea that challenged experts' opinions should be admitted, or should only be excluded only if it is so fundamentally unsupported as to be unhelpful. That's predominantly discussed in federal courts in the Eighth Circuit, but that very same language has been picked up in state rulings in a number of jurisdictions. I was able to find Georgia, Missouri, and Texas. There are almost certainly other state courts, I suspect, predominantly within the geography of the Eighth Circuit. Similarly, in the Ninth Circuit, they phrase it as challenges ought to be examined with a liberal thrust favoring admissibility. That's been picked up in state courts in Arizona. Similarly, in the Third Circuit, they talk about a liberal policy of admissibility, again picked up in the state courts. And in the Sixth Circuit, they're very explicit. Doubts regarding admissibility should be resolved in favor of admission. Again, none of these square with the straight up notion that a preponderance applies. And these kinds of judicial thumbs on the scale, these applications of a policy preference for admission over exclusion, which come from sometimes from dicta, but as we'll see, some of these actually originate from even pre-Daubert notions of the judicial gatekeeping responsibility, and they set up a scenario that is inconsistent. That addressing this problem, that courts are using different standards and much more lenient standards than has been present all along, is one of the motivations for rolling the preponderance language right into the text of the rule. Angelica, we could move to the next slide, please. Another problem that has developed is whether, and this is why the explicit reference to the court was added right into the text of the rule, is whether these decisions are court functions that the judge must make, or whether these are properly deferred to the jury. Despite the rule, what we see is that many, many courts have rejected the role as decision maker on the element listed in Rule 702B, whether there is sufficient factual foundation for the expert's opinion. There are two very notable quotations that come from cases, the Loudermill cases from the Eighth Circuit in the late 1980s. The Viterbo case that you see referenced in the second quotation comes from the Fifth Circuit, also from the late 1980s. And this text has been rolled forward again and again, both to the same effect that this issue of whether an expert has a sufficient factual foundation is a matter of weight for the jury to decide, not a matter of admissibility for the court to decide, has been rolled forward again and again in hundreds and hundreds of recent opinions. And it's not limited to just the federal courts. We see, and you can see the listing there of state rulings that I have been able to dredge up without much effort, frankly, at all. That these same mistakes that ascribe the responsibility for determining factual foundation to juries as opposed to judges get applied in state courts as well. And as we'll discuss, and as I mentioned just a moment ago, both Loudermill and Viterbo are cases from the 1980s. So what that means is they're not interpreting Rule 702 as it was amended in the current version back in 2000. They're not even interpreting Daubert. Those cases predate Daubert. So they are not an application of modern understanding of the gatekeeping responsibility. And the fact that they're being rolled forward is just, again, fundamentally inconsistent with the way the rule has been structured, and that requires the clarification that we see in the amendment. And Angelica, we can go to the next slide, please. And there's one more instance of fundamental court problems in understanding and applying Federal Rule 702 as it currently exists. And this relates to the Rule 702D requirement of reliable application of the methodology to the facts of a particular case. Again, this is an admissibility criteria. It's built right into the text of the rule. This is a matter for the judge to apply, to make a decision based upon the preponderance of evidence. But yet we see in case after case, judges saying, no, I'm not going to take on that responsibility. I'm going to defer that to the jury, and I'm going to make that an issue of weight and not admissibility. Once more, what we see is a fundamental failure to understand and apply the rule, confusion by courts about what the rule requires, and by inserting the court as an explicit, with an explicit reference that identifies the court, the judge, as the decision maker, that amendment that we see to the forthcoming federal rule is necessary in order to square practice with the actual requirements of the rule. And again, this is an issue that we see played out in state courts as well as federal courts. Alex, I'll turn it back to you.
Great. Thank you, Lee. I want to take you through what LCJ research has shown about the origins or the existence of this problem. And before I do that, I want to give a little bit of background about kind of how we framed the questions. Angelica, you could go to the next slide while I'm giving the background. I mean, here's the mystery. The Daubert decision was made in 1993, and in the subsequent couple of years, the other two cases that became known as the Daubert trilogy were decided by the Supreme Court. I think it is fair to say a little politely here that there was a need for clarity even after those three decisions. And so a rulemaking effort took place by the Federal Advisory Committee on Evidence Rules to make sense of the trilogy and to put it down in writing so that it becomes the rules for all federal courts. So a little bit of background might be helpful here too, and that's this, that the process of federal rulemaking is governed by the Rules Enabling Act, which is a law passed by Congress that delegates to the Supreme Court the responsibility of promulgating procedural rules and rules of evidence in the federal courts. Because of this process, which begins with the advisory committee and includes an open public process and comment period, and then review by the Supreme Court and approval if they so choose. And then importantly, it goes to Congress for a period of review as well. The import of all of that is that this is a law and it's binding on all courts. And the Rules Enabling Act gives that process the power to state what the law is, even if there is contrary case law before before that rulemaking. So this kind of that background kind of informed our question, which is, are courts really doing what Lee just described, the mistakes, misunderstandings, and misapplications of 702 on a demonstrable basis, and why that is? So what we did is reviewed every federal decision in the year 2020 that had anything to do with expert admissibility. There are 1,059 such decisions. And as you can see in this chart, what we found was an overwhelming demonstration that the rule 702 is not being expressly referred to or followed in a substantial number of federal cases. So that first block says that 65% of those cases did not mention the standard of the burden of proof for admissibility, the preponderance standard, which is now part of the upcoming amendment to 702. But that's just a huge number, 65% of cases not referring or describing what the standard is that they're using to decide. That's the biggest number, but some of these other numbers are almost equally, if not more, astonishing. So 13% of cases not only failed to mention what the standard is, but got it completely wrong. So instead of saying that there is an admissibility test and the court has to make the decision and that the profferor has a burden to prove admissibility, 13% of these court decisions say the other way around, that the rule has a liberal thrust favoring admission rather than a burden on the profferor. Most astonishing of all might be this smaller number, 6%. But 6% of the federal cases on expert admissibility cited both standards, which are, of course, incompatible with each other. They said both that the profferor has a burden and that the rule is essentially has a bias in favor of admission. So completely incompatible standards, and 6% of the decisions citing both. So this really demonstrates what is going on with a mixture of courts not focusing on the rule as the source of the standards that they are supposed to apply, that even the ones that are looking at the rule are either misunderstanding or misstating the rule's requirements, and some degree, 6% of real confusion about what the rule means. Looking at these results, Lee undertook a really interesting research project to answer the question, since we know all that's going on, why is it that courts are not focused on the rule and getting the standards wrong? So Lee, why don't you walk us through your innovative research that can answer that question?
Thanks so much, Alex. And this was really a very fun project because, as I mentioned earlier, we see hundreds and hundreds of cases that quote essentially the same language that we'll talk about that gets the issue flatly wrong and suggests that these issues, in particular the issue about whether a court or whether an expert has a sufficient factual foundation to justify and support the opinion, is that a matter of admissibility for the court, which is very straightforwardly indicated by the text of the rule, or is it a matter of weight for the jury, which is thrown out by the case law? And the specific quote is, as a general rule, the factual basis of an expert opinion goes to the credibility of the testimony, not the admissibility. And having seen that language show up again and again and again in the case law, I started to wonder, where is this coming from? Because it just flatly cannot be reconciled with the text of the rule. And I saw references, with very recent cases, very recent appellate court cases that cited this very same language, and I just kept wondering how can this be? So there was one case in particular that encapsulated a number of the issues. This is actually this Trice case that you see identified on the screen is actually one of the 6% from Alex's slide. It on the preponderance question, the standard, it sets forth both the preponderance standard and also a liberal thrust approach. Yeah, so that caught my attention, but then it went forward and quoted this language from the Loudermill decision as a general rule. Factual basis goes to credibility of the testimony and not the admissibility of the testimony. And it cited to a quite recent Eighth Circuit decision called Finch. All right, so the language comes from Finch. So I went back and looked, well, where did Finch get that statement from? Well, Finch actually quoted that from a previous case called Rodriguez. Rodriguez's case took that very same language from an earlier case called Arkwright, and you'll see that's from 1997. So that predates Federal Rule of Evidence as adopted, Federal Rule of Evidence 702 as adopted in 2000. So already we're pre-rule, but wait, there's more. It goes back even further. The Arkwright case drew that sentence from an earlier case called Hose that goes back to 1995. And Hose, in fact, pulled those very same words from that Loudermill decision that I mentioned earlier, which is a 1988 ruling. It's pre-Daubert. It's pre-Rule 702. So it's not interpreting any of these. It is simply a statement that was taken at a point in time before the Supreme Court had offered its guidance with Daubert and the other Daubert trilogy cases like Humo Tire and the updated version of 702. And so courts have been carrying this language forward and cloaking that language with updated case sites, not recognizing that the very concept that it stands for doesn't come from it. It doesn't even come from Daubert. It comes from, it is a court invention that was displaced, as Alex explained, by the enactment of Rule 702 pursuant to the Rules Enabling Act. So this reliance on case law concepts that have been rolled forward that are fundamentally inconsistent with the text of the rule itself and with the direction of the rule that is fundamentally problematic. And it's interesting when we apply the same DNA analysis to one of the other issues that I talked about, and that is these judicial thumbs on the scale, the presumptions of admissibility, be it through liberal thrust or so fundamentally unsupported. When we look at a lot of those case references that spawn this judicial thumb on the scale, we find the same thing. And interestingly, if we did this same analysis in the language that's quoted in the Trice case, it uses the so fundamentally unsupported preference for admission over exclusion. Trace all of that back. Again, we get to the same sequence, and it ultimately leads to, and it shows something that remarkable happened. That language actually also originates from the Loudermill case. But what happened is in the rolling forward of that language from one decision to a subsequent decision, it went from a very uncontroversial process or concept that if an expert's opinions are fundamentally unsupported, then it should be excluded. That's probably not even controversial. If there's no factual foundation, so it is fundamentally unsupported, then yeah, it ought to be excluded. But in rolling that forward, only was added at the next step, and that changed the conception of the test entirely from one that was uncontroversial to one that flatly contradicts the preponderance standard that's set forth in Daubert. And what we also see, and I mentioned this earlier as we were walking through the 702B problem, is that this isn't isolated just to the federal courts, as is likely to be expected. There's a lot of pass-through of concepts because a lot of the federal cases are published and easily accessible. The language that is set forth in those decisions gets picked up in state orders, in state gatekeeping rulings. And so we see these same problems, the same language that has been rolled forward again and again, but that is inconsistent with meaningful gatekeeping and certainly inconsistent with Federal Rule of Evidence 702 and the language of Rule 702 and certainly the intent of 702. So I find that to be a fascinating foundation for the problem that we see on both the federal side and the state side in how judges are approaching challenges to the admissibility of experts. Alex?
So we've talked about two of the major causes of the problems, and just to summarize, those are the sort of non-focus on Rule 702 and the misunderstanding of what it means. And then, as Leah's just walked through, this very compelling case for how the case law has essentially become misleading because it has not taken into account the very important changes, most especially that there is now a rule that that takes precedence over the case law that preceded it. And so these are the two major problems. I would also like to offer a third, and this really is the responsibility essentially of everyone in our profession, and it has to do with the language that we use. I'm sure you all are well aware that expert admissibility is referred to as Daubert. You have Daubert hearings, Daubert motions. We won on Daubert, we lost on Daubert. That is the slang word for expert evidence admissibility. It is a misleading way to use language in a profession where language really matters. Misleading not because Daubert's unimportant, of course it's important, but because Daubert isn't the standard. Rule 702 is the standard. And so one thing that would really be helpful for everyone is to change our language, to refer to these what it really is. These are Rule 702 hearings, Rule 702 motions, and you win or lose a Rule 702 motion. And that would have a great impact on making everyone involved focus on the rule and what it means, rather than on the case law, which has numerous problems, as we've discussed, that Daubert isn't the last word, and that a lot of the case law that refers to Daubert is in fact antiquated and has been taken over by more current standards, in particular 702, and now this forthcoming amendment to 702. So if we could go to the next slide, we have an effort underway that we have designated Don't Say Daubert, a catchy phrase for this idea that our language as lawyers ought to conform with the reality of where the standards are and what they mean. And since I've got the slide up, I also want to tell you all that there are, on the state rulemaking effort, that there is a website called don'tsaydaubert.com, and it is a great resource for everyone who wants to understand the rulemaking that led to this amendment that's going to take effect in 3 weeks, that all the reasons for it and arguments for it, and also resources for the states that are currently looking at their own Rule 702 equivalents with an eye toward making similar or identical amendments. And of course, all of the information that was discussed and considered by the Rules Committee is relevant to any debate or reform efforts on the state level. This website will also soon have state-by-state information about where reforms stand in various states. So in most states, this is nascently getting underway, waiting probably for the federal rule to take effect. There are, however, a few states that are moving forward And Lee, maybe you want to mention something about Arizona, but the handful of states that are underway, most of them are at an earlier stage. But what we predict is that over the next couple of years, let's say, that probably most states are going to take a look at their expert admissibility standards, because all the problems that Lee has been describing with practice under the federal rule, are alive and present in state courts. Some of them with additional or slightly different issues, but very much the same. And so states and state courts really have reason, not just because the federal system has done it, but informed by the reasons that the Federal Rules Committee looked at it, to take a look at their own rules and see if there are similar problems that need a similar rulemaking solution. Lee, do you have any other thoughts or comments on that topic?
Yeah. You mentioned Arizona, and it appears to have been the first mover in response to the adoption of the Federal Rules of Evidence 702 amendment. It, through the Supreme Court, adopted verbatim the same amendment to its state court rules. As I understand it, it is effective January 1st of 24, so one month after the federal rule goes effective. To my knowledge, that is the first state to have taken final action to move in that direction. As Alex mentioned, a number of other states have begun the process by initiating public hearings, or at least starting to develop an agenda that includes consideration of the amendment. And that's probably not surprising. I think at last count, about 35 different states have adopted within their evidence code something that looks a whole lot like the Federal Rule of Evidence, and then several other states have adopted by judicial action either what they describe as the Daubert standard, although we shouldn't say Daubert as the slide shows, but a number of states have embraced in addition to the federal rule, states have embraced the notion of judicial gatekeeping to evaluate the reliability of proper evidence. So we'll see that process carrying forward, and for good reason. The same problems are present on both the federal and the state systems, and fundamentally the notion of uniformity, I think, informs state action to move in the same direction, corrective direction, that the federal system has. Evidence that is unreliable, that is misleading to a jury, that can encourage juries to take action that is, frankly, inconsistent with a reasonable methodology. That shouldn't vary. I mean, just on a logical level, that shouldn't vary depending on whether we're on the federal side of the street or the state court side of the street. It's a similar level of justice ought to apply on both sides, and that reaches the notion of whether expert testimony is reliable and the sort of thing that a jury ought to be able to consider, as opposed to something that is so fundamentally misleading and fundamentally unreliable that it ought not to be considered.
One additional thought about the Don't Say Daubert website, for any of you who are interested in engaging in your own state rule examination of their state equivalent of Rule 702, there is a place on the website where you can sign up. So this is going to be kind of a gathering place so that you will know who else is interested in your state, and they will know of your interest. So it'll be a little place for people to know who's working on it and interested in working on it together. So I encourage you, if you're interested, to sign up on the list for your own home state to get involved.
And Angelica, if we can move to the last slide, please. So just to wrap up, and then we can turn over the discussion to some questions. I want to offer a few conclusions from the analysis that I have done and that Alex has done and others. And I want to start with this notion. If you take away nothing from this presentation other than this point, we'll still have been successful. Hopefully, through all of the problems that I've shown you, whether it's with the DNA analysis or whether it was the sequence of issues that led to the adoption of the federal amendment, the case law is really problematic, and relying and rolling forward chestnuts that are included within the case law about the standard, about the role of the court. Relying on the case law is terribly problematic because of so many of the misapplications and misunderstandings that are pervasive throughout the case law. The federal rule, well, the rule of evidence sets the standards. Under the Rule Enabling Act, that is the law. The advisory committee's amendment is intended to make the rule easier to follow, to include the elements right within the text of the rule, so there shouldn't be any further confusion. And so relying on the text of the rule and the criteria laid out in the rule itself is a much safer way to go. It is a much more appropriate way to go. In terms of what the amendment actually does, it clarifies that it is a court decision as to all of the 4 elements that are listed in the subsections of Rule 702. So qualifications, sufficient factual foundation, reliable methodology, reliable application of that methodology to the facts of the case. Those are all decisions that the court must decide as a matter of admissibility before the jury gets a chance to consider that evidence. That set of criteria must be satisfied by the preponderance standard, and this responsibility on the part of the court is ongoing. And once the 702 hearing is done and the court issues a ruling that the expert is allowed to testify, there is still a responsibility for the court to police the expression of those opinions so that overstatement doesn't occur and doesn't pervade the process. And fundamentally, as Alex has mentioned, and as I would absolutely emphasize, this amendment is meant to change practice. It is intended to clarify and to correct ongoing problems that courts and litigants have been undertaking for years and years. These problems pervade not just the federal jurisprudence and the federal rulings, but also state practice as well. And so in order to bring practice into alignment with the intent of the rule and now with the language of the rule, those practices have to change. Reliance on the old case law, reliance on the old concepts just isn't appropriate anymore. Those practices need to change and focus on the text of the rule. So with that, I think we're ready to open things up to questions, Ashley. And it looks like we have a couple.
Excellent. Just a reminder to the audience that if you have a question, please submit it in the Q&A box at the bottom of your screen. Let's begin with this one. So some critics of the forthcoming amendment say it will usurp the role of juries by putting judges in the position of weighing the expert evidence. Some even characterize this as depriving parties of their right to a jury trial. Is this a valid criticism of the amendment?
I'll take the first stab at that. I think that is, I've heard that before, but I do not think it's a valid criticism of the rule amendment. The rule and the amendment makes clear that judges are not deciding essentially who's right and who's wrong, but rather whether the expert has the qualifications, the methodology, has applied the methodology in a reliable way to the facts of the case. And so that decision of admissibility leaves to the jury the important role of considering the weight. So it is not meant in any way to usurp the jury's role. It's meant to enhance it. And I'd also observe that the principle that has caused some of the problems that Lee walked through about the preponderance standard for admissibility is actually a principle that applies to all the rules of evidence. This isn't something that's new to 702 or even to the rules of evidence. That applies to all of them and is nothing new. It's well accepted and well understood. It's just that in this particular area of 702, it has been misapplied or not applied or whatever other reasons not focused on by the courts. And so the idea of this amendment is to make express what was already the law, but not stated expressly in the rule, and that is that the preponderance standard is the burden that the profferor of expert evidence has to overcome.
And Ashley, if I could just pick up on that, if you look throughout the rules of evidence, you see that the judicial responsibility to engage in gatekeeping, or put another way, to determine if admissibility criteria are met or not, that is the function of a judge, and the federal rules of evidence are shot through with examples. So immediately comes to mind is Rule 403. So balancing the probative value of evidence against its prejudicial weight. Is that somehow eliminating a jury consideration of something? Well, no, that's an inherently judicial function of determining if those admissibility requirements are present. Similarly, excited utterance under the hearsay rules. It's up to the judge to decide if the circumstances are present to allow that evidence in. So this is fundamentally no different that when we look at judges evaluating whether the admissibility criteria for expert testimony is met as a whole. That's just a judicial function. And because the amendment to 702 is a clarification, what I think this criticism fails to appreciate is there's no substantive change that's going on with this amendment. This has been the gatekeeping responsibility for judges all along, since 2000. So for the last essentially generation, this has been a judicial function. And to suggest that there is something new, that is something dynamic about this amendment that inserts the court into the fact-finding function, I think is a misunderstanding of what the gatekeeping responsibility is and always has been about. And maybe to turn it on the flip side, what this is arguing is that there ought to be some sort of a fundamental right to put in front of juries opinion testimony that is factually unsupported, that is based on an unreliable methodology or is based on an unreliable application, that there is some sort of a right to do that, a right to mislead the jury, a right to put inadequate, unreliable evidence in front of the jury. I think our justice system deserves better.
Thank you. Okay, for the next question. You stated earlier that the amendment is meant to change court practices, but the committee note to the amendment says that it is only a clarification of existing law. Is there a tension between the idea that this is a clarifying amendment and yet one that is intended to change practices?
Well, that's a good question. And I think that this is something that's going to be talked about as this amendment takes effect in 3 weeks and courts start focusing on it. But I do not think that there is tension between those two concepts. The fact is that the rule has meant what it will mean after the amendment all along. It's just that a lot of courts have not been focused on the rule, and a lot of courts, frankly, have misunderstood it. And I don't mean to place all the blame on the courts. I think that practitioners are equally, if not more, responsible for perpetuating the misfocus and misunderstanding. But anyway, the rule amendment is going to clarify this for everyone. It's going to be a very positive development. Of course, in the courts and the jurisdictions where courts have been getting this right, it will of course be no change. And that's really, I think, the lens to look at that question about whether the rule changes. It is not meant to change practices that are in appropriate applications of the rule today, but it is absolutely meant to change the practices in courts and jurisdictions that have been misstating the meaning of the rule. And so yes, it is both. It is both a clarification and meant to change the practices in the courts that, for whatever reasons, as we've discussed, courts have not been focused on that fact that Rule 702 is the standard and what that rule means.
And maybe to state it a little bit more boldly, it is a clarification with consequences, and it was made because courts and litigants, but especially courts, are getting it wrong. And if you look at the advisory committee note to the forthcoming amendment, they're explicit about that. The rule isn't improving grammar, or the amendment isn't about improving grammar. It is about making sure that these errors that we've been describing, these failures to apply the preponderance standard, the failure to appreciate what the gatekeeping responsibility requires of judges, needs to get corrected. And that's what the clarification is all about. And so inherently, it's going to need to change practice because courts and litigants are getting it wrong.
Right, here is one from the audience. When the new e-discovery rule went into effect, some judges, even at the appellate level, continued to rely on the old standard. What can be done on a broader scale to remind judges that the amendment is in effect?
Well, that is a very savvy observation about the rulemaking process, and an observation that the Rules Committee and other observers know all too well, and that is that, for example, in this instance, when the language changes, the language of Rule 702 is going to change on December 1st, but it's not as if every single lawyer, litigant, and judge is going to pick up the copy on December 1st and read it and understand what it means, and there will be 100% adherence immediately. These things take time, and it's an educational process. So to the question of what needs to happen, I think that great efforts like from the Law and Economics Center to publicize the change and to have explanations, and I think are just really important. And the same thing should be going on in all the usual places, in law schools and bar associations and law firms and all other groups where people who care about the profession meet. There should be this discussion about the change and what it means and what it should mean going forward. So I think there's a big educational component to this, and I hope that we can, all of us can do our part. I'll put another pitch for changing the language while we're doing that. I think it's really important to make sure that we're talking about what we're talking about, which is Rule 702.
And as a practitioner, I'm going to speak to the practice. If the rule is going to make a difference, then practitioners have to act differently. There is a tendency among many lawyers out there when they're facing a challenge or approaching a challenge, raising a challenge to the admissibility of an expert, to just dust off their last quote Daubert brief and reconfigure it and roll it out with application to the new expert in the new case. That can't happen anymore. The emphasis on the case law needs to be eliminated, and the focus on the rule needs to replace that. And likewise on the judicial side, I don't think it's appropriate any longer for judges to instruct their clerks to simply just dust off the last ruling and roll forward the same discussion of the law. This clarification in the amendment means that that law needs to be re-examined and reevaluated. So the practice on both sides of the bench and the bar needs to be reconsidered and needs to be reconfigured in order to get this. And ultimately, it's going to come down to the appellate courts policing this function. And if courts are continuing, as some likely will do, continuing to roll forward some of these same old references from Loudermill and Viterbo and liberal thrust favoring admissibility and all of that, it's going to be the responsibility of the appellate courts to say, no, the rule was amended. The rule was amended for a reason, and the amended rule governs. That's ultimately what I expect we're going to need to see.
Right. In our last 5 minutes here, we have a question that's sort of looking at this from a slightly different angle. So the audience member wants to know, how will prosecutors react to the new amendment to Rule 702 if, as it seems, it may become more difficult to admit in criminal cases findings from questionable forensic sciences?
Really good question. And it involves, the answer involves the history of this rulemaking process, which from its very beginning a couple of years ago really had a very large component about forensic science. And that was a major topic that the Rules Committee spent time and effort to understand, and numerous prosecutors and defense lawyers weighed in on a variety of topics that related to Rule 702 and admission. In fact, the third part of the amendment that we spoke about earlier, which is the one that the Rules Committee referred to as addressing overstatement, and I referred to as an ongoing obligation of the court, in particular, has its roots in concerns about forensic science in criminal cases. So it may well be, as the viewer suggested, that prosecutors could have more difficulty if courts have not been following the standards to get expert evidence in. But I think that there really were a number of serious problems presented to the Rules Committee about forensic science, and a very serious and thoughtful look to make sure that forensic science be reliable in criminal cases. So I think that's has been very seriously considered and factored into this amendment, and it will have an effect in criminal cases, undoubtedly.
Yeah, I think that's right. And through the rulemaking process, it was interesting to see how lawyers from the Department of Justice were discussing and describing their intended actions with respect to the observed problem and issues with overstatement. And there were representations made at certain points that there would be increased self-policing within the Department of Justice to try to rein in some of the circumstances and some of the types of testimony that gave rise to the concerns that the advisory committee raised along the line. But to the viewer's question, in particular, I think there are going to need to be changes in practice, and I think particularly when it comes to statements offered by experts about a degree of confidence in the outcome. This is an absolute match. Testimony like that, unless there is good scientific grounds for that, or this is 1 in 10.3 billion, when that number is just plucked out of thin air. I think that's going to be very problematic. I think it's going to get a lot of scrutiny, and probably appropriately so. And experts are going to need to, and the prosecuting attorneys who sponsor that testimony are going to need to be very cautious about going that extra step to express that degree of confidence, unless there is a very solid basis for making that statement. I think it could potentially render the testimony vulnerable.
Ashley, I know we're right at the end here. I do want to address, if it's okay, I see in the chat box or the Q&A box a question about whether this rule amendment is going to require a hearing even when there's no objection. Just want to touch on this. For what it's worth, my reading is no, of course not. I don't think that the preponderance standard that is articulated now in this amendment is going to be any different from how it applies to other rules of evidence. That if somebody offers hearsay evidence and the judge says any objection and it's no, it comes in. I think that this rule will work in a similar way, that it is not meant to require a hearing and analysis for no purpose, but rather only when there's a challenge to the admissibility. I don't know if Lee, if you want to weigh in on that, but that's
just real quickly. I just want to note that the advisory committee comment actually speaks to that and backs up what Adam says.
Great, and that is about all the time we have today. Thank you to our panelists for a great discussion, and thank you to our audience for tuning in. We will have more of these webinars in the new year, so please keep an eye out. You can find information about all of our upcoming webinars at masonlec.org. Thank you again for joining us, and have a great weekend.